So we just received huge Second Amendment news out of the state of Texas. The Supreme Court's Bruin decision was just used to remove the state of Texas ban on 18 to 20-year-olds from being able to carry concealed out in public for self-defense. And that was part of the Texas constitutional carry law, which was just struck down. So let's talk about this. But real quick before we jump into this video, if you agree that 18 to 20-year-olds have a constitutional right to keep and bear arms, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll leave a link to them down in the details section. So like I said in the intro, the Supreme Court's Bruin decision was just used to remove the state of Texas's carry ban on 18 to 20-year-olds, which came from the Texas constitutional carry law that they passed last year. This decision marks a huge point in our history where a court is finally correctly applying the text of the Second Amendment as informed by our nation's history and tradition to remove these types of restrictions on public carry. This is also a huge win for young adults who to this point have been treated as second-class citizens when it comes to exercising their rights to keep and bear arms. Now, this decision and case we will be talking about in this video is FPC v. McCraw. This case was filed in the Northern District of Texas, and it challenges the state of Texas laws, which makes it illegal for 18 to 20-year-olds from being able to carry handguns for self-defense outside of their homes. Under Texas law, a person commits an offense if the person 1. Intentionally carries on or about his or her person a handgun, 2. At the time of the offense is younger than 21 years of age, unless the person is on the person's own premises or premises under the person's control, or is inside or directly en route to a motor vehicle or watercraft that is owned by the person or under the control of the person. This language prohibiting 18 and 20-year-olds from being able to carry concealed or being able to carry out in public was included in Texas House Bill 1927, which created constitutional carry in the state of Texas. As most of you know, Texas is now a constitutional carry state because of HB 1927. Because of this, most Texans over the age of 21 can carry a handgun either openly or concealed outside of their homes with or without a license to carry concealed. But 18 to 20-year-olds cannot carry even though they are considered to actually be adults. They can get married, they can enter into binding contracts, they can even go to war, all of that stuff, but they cannot carry out in public. Now, this decision by the court comes in the form of granting a motion for a summary judgment. Simply put, a motion for a summary judgment is a motion filed by one or both parties asking the court to decide the case before it even goes to trial. Here, both the plaintiffs and the state of Texas filed motions for summary judgment. Those were cross motions, but the judge granted the motion in favor of FPC and those plaintiffs, which ultimately found that this law does indeed violate the Second Amendment. And in finding that, the judge used the Bruin standard. Justice Thomas, writing for the majority opinion in Bruin, stated, "In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. Only if the firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." So the Bruin decision reaffirmed that text as informed by history is the appropriate analysis. And also in the decision, the Supreme Court expressly rejected the two-part test and interest balancing, which lower courts in the past had used to uphold these types of restrictions. So the Supreme Court in Bruin set the foundation, and this court here and the judge here in this case used it to find that the Texas 18 to 20 ban on public carry for self-defense was indeed unconstitutional. Federal District Court Judge Mark Pittman stated in his order that this issue is whether prohibiting law-abiding 18 to 20-year-olds from carrying a handgun in public for self-defense is consistent with the nation's historical tradition of firearms regulation. Based on the Second Amendment's text, as informed by founding-era history and tradition, this court concludes that the Second Amendment protects against this prohibition. Texas's statutory scheme must therefore be enjoined to the extent that law-abiding 18 to 20-year-olds are prohibited from applying for a license to carry a handgun. So the judge in this case applies the analysis as outlined in Bruin. He first started with the text of the Second Amendment. He stated that it is undisputed that the Second Amendment protects an individual right to carry a handgun for self-defense outside of the home. That much is absolutely clear and was expressly stated in Bruin. Bruin said that you have an individual right to carry a handgun to carry a firearm outside in public for your own self-defense. The right is not isolated just to your home. Therefore, the only further question the judge said is if law-abiding 18 to 20-year-olds are afforded the same type of protection. And really, that question only hinges on whether 18 to 20-year-olds are part of the people as mentioned in the text of the Second Amendment. And this judge correctly found that they are. He stated, to start, the Second Amendment does not mention any sort of age restriction. This absence is notable when the founders meant to impose age restrictions, they did so expressly. Instead, the Second Amendment refers only to the people, which various founding era dictionaries defined as a reference to those who make up the national community. In accord with that understanding, Heller said that the people is a term of art that refers to all members of the political community, not an unspecified subset. And without challenging Heller's interpretation, Bruen said it was undisputed that ordinary, law-abiding adult citizens are part of the people whom the Second Amendment protects. With this guidance, the court asks a simple question. Are law-abiding 18 to 20-year-olds properly considered members of the political community and a part of the national community? The answer, he said, is yes. And based on that answer, the court concludes that law-abiding 18 to 20-year-olds are part of the people referenced in the Second Amendment. Since the court found that the text does in fact cover this type of conduct in question, the only question then is, does the state of Texas meet their burden of showing there is some sort of analogous history or tradition dating back to 1791, which justifies this age-based restriction? But the judge finds that there is no relevant history or tradition of age-based bans on public carry. So the judge granted FPC's motion for a summary judgment and enjoined the enforcement of that Texas ban on 18 to 20-year-olds. Another important thing to note is that he did issue a stay on his own judgment for 30 days. During that period, the state of Texas can appeal the decision up to the 5th Circuit and also seek a stay from the 5th Circuit, a permanent stay for them to enjoin this judgment by this lower court judge. Whether or not the state of Texas is actually going to do that, that's up to them. They need to decide if they're going to further litigate this case. First, one thing the state of Texas could do is simply just bring 18 to 20-year-olds within the state constitutional carry provisions, but the state could also establish a concealed carry permitting requirement for 18 to 20-year-olds. In footnote number 9 of the decision, the judge stated, though Texas cannot impose a substantial burden on public carry for 18 to 20-year-olds, Texas could, under Bruen, require 18 to 20-year-olds to satisfy additional objective criteria when compared to those above the age of 21. So there the judge in this opinion said if Texas had a shall issue permitting scheme for 18 to 20-year-olds, then the law in question would likely be lawful and he would have ruled a different way. But since Texas has an outright ban on 18 to 20-year-olds from being able to carry in any regard, even with a permit, he found it was unconstitutional under Bruen. So one of the simple fixes for this is for the state of Texas to issue 18 to 20-year-olds permits on a shall issue basis. So like I said, this is a huge win, and we finally see a court correctly applying the Supreme Court's Bruen decision and ruling in accordance with text and history of the Second Amendment. Now, if you're an 18 to 20-year-old in the state of Texas, this judgment is not yet in effect, so just be aware of that. You cannot just walk out your door right now and concealed carry under constitutional provisions or anything like that. The judgment is not in force yet. It's been stayed for 30 days, and the state of Texas will need to decide what they're going to do, but we will wait to see what actually they decide to do. Are they going to further litigate this case, or are they going to change some of their base laws and maybe shall issue permits to 18 to 20-year-olds? So we will definitely be keeping our eyes on this case. If you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.